Moving on, we start with the session 1. I would like to invite Mr. Manoj Kumar, who is the managing partner of Hammurabi Solomon. Mr. Kumar is an alumni of the Harvard Business School and the National School, Bangalore. He is known for his immense expertise in providing cutting-edge solutions to often complex regulatory and legal issues. Welcome, sir. Next on the panel, we have with us Mr. Amar Sundaram. He is the National Director, Legal and General Counsel for Ernst & Young Services. Mr. Sundaram has a rich experience in strategic thinking, formulation of operational guidelines, and business and legal decisions, and have worked with some of the best business houses like DCM Shriram, Birla, Tata, Reliance, Citi, and now EY. Next, we have with us Mr. Ramesh Vaidyanathan, founder and managing partner of Advaya Legal. He has extensive experience and expertise in general corporate matters, projects and infrastructure, and aviation. Further, we have with us Mr. Tushar Chawla, India General Counsel and Director at JLL. Prior to JLL, Mr. Chawla was the partner at ALMT Legal. He has been associated with firms like ELP, Kocher & Co. Now that we have our panel set, I call you, sir, on the stage, please.
Many thanks, Swati. In fact, is my PPT on? Yeah? Yes, so you're right. In fact, we don't need a PPT for this kind of a topic. But somewhere, I was requested by Beetika in some way that possibly we'll have a wider audience, and this issue is like an elephant in a dark room for quite a few of us. So while we keep hearing about it from here and there, from the news, from bar associations, from SILF, from the media, I think there's yet some time before everybody is at the same plane about what this issue is all about. So this is an attempt. I was requested to just give an overview, an informational overview, almost like a bird's eye view about liberalization of legal services, hence the PPT today. And before I move on with the slides, I would just like to touch on what Beetika mentioned in the beginning, that probably the response she got from quite a few colleagues of ours from different law firms, that this is a very sensitive topic and probably some of them are not allowed to speak about it. What is the fear factor all about? Any issue for that matter, I mean, this is a matter of policy. It could be concerning the legal fraternity, but ultimately it's a matter of government policy. And any policy is to be debated, and that is how any policy takes shape. So why a fear factor? Where is the fear from? Is it from insecurities of some of the stakeholders concerned? Is it from diktat not to speak, and why and who is giving the diktat? Or is it from the fact that we don't understand what animal this liberalization is all about? And till we fix that, I think the larger group of stakeholders will not emerge. And as much as we have been seeing since 1989, 90, since the liberalization has started opening up in all different phases, in different sectors, the issue of protecting the India Inc. in that sense, for that sector, has always been the starting point. And in each and every sector, we have competed to the global players, and we have been second to none, as Dr. Bhasin mentioned, that we are indeed ready for opening of the legal sector. So why then make it an issue to be feared about by anyone for any reason at all? Therefore, it needs to be debated, it needs to be understood, and the inputs and the understanding of the government also has to mature to the concerns of the larger group of stakeholders. Law firms, no doubt, are the biggest stakeholders. They are the service providers who are catering to the needs of the clients, possibly in the areas where the law firms from overseas are going to step in case they are allowed. So obviously the single most impacted class of stakeholder are the law firms in India, but then law firms in India of different shades, different sizes, different capabilities, different expertise, and each of them are circumstantially differently placed. So unifying the stakeholder as a law firm, as one class, may or may not, I'm just raising a question here, may or may not be reflective of the issues concerning the law firms when we talk about liberalization. SELF, for example, has more than 130 members. It's the single largest representative of law firms in India, rather the only, if I can call so. And I'm a very proud office bearer, and I've been able to assist Dr. Bhasin and SELF for the last about 5 years in different capacities in doing some meaningful work. Having said that, out of the 135 member body, if we look at the demography or the constitution of the different law firms, we have sole proprietorship concerns, we have partnership concerns of different sizes, we have firms which are very uniquely placed in terms of offering in practice areas. So can we really unify and create a single class for all of them? Are all of them impacted in the same manner by opening up of the legal services? And when we are talking about the impact of liberalization of legal services in India, so candidly and so lucidly, in an environment where only the stakeholders are sitting, of course we should understand what are the impacts that we're talking about. Impact on revenues, impact on talent loss, impact on training, impact on what? Apart from the other issues that the BCI needs to fix, because yes, the BCI needs to fix, and whatever the BCI needs to fix can be fixed at a very fast pace if the government decides to do so. As we have seen from time to time, that if it is a wish list of the government, time is not a constraint, consensus is not a constraint. It comes within days, if not weeks. With this, let us try and have an overview of the issues around liberalization of legal services in India. Not very long ago, we had, let's understand where is this coming from? Why is it gaining momentum now? Why not a few years ago? Why not 3 years ago? Why not 4 years ago? The discussion has been on for very long. Why now? Why the urgency of 15th August? Why the urgency of BCI rules? Even before BCI actually consulted people about the draft rules. Why a sudden push from the government and the BCI? Well, the push is possibly coming from the overall environment of reform that the government is trying to deliver with a roadmap towards transformation and development. Some of it is reflective from our Prime Minister's comments not very long ago. Reform is not the end in itself. Reform for me is just a way station on the long journey to the destination. The destination is the transformation of India. So this is what I would like to set the stage very clear, that when we talk about liberalization or any policy reform, we have to look beyond any single stakeholder issues. We have to look at the issues in the context of the larger destination and of course address those issues, but not let that issue become a roadblock to stop the reform. So any anomaly that we come across in the draft rules or any other legislation or initiative, I think the effort has to be to rectify, to correct that and to move ahead rather than send it back on another round of working by the BCI or the Government of India. A little short FAQs about the liberalization process so far. We have the Advocates Act, which we are, Dr. Bhasin already mentioned, and we are quite aware of, that it permits practice of law by citizens of India enrolled under the Advocates Act 1961. Law practice in India constitutes mostly transactional and litigious work, as in most other jurisdictions. Multidisciplinary practice is not yet recognized as a law practice in India. The GATS negotiation resulted, India did not make any commitment with respect to opening up of the services, legal services in India. And India, as a contracting state of GATS, is yet to comply with trade in services. Many member countries like US, European Community, Australia, Singapore, Japan, China, Switzerland, New Zealand, Brazil have been making requests from time to time to India to meet the commitment to try and open the legal services. In November 2015, the Law Society of England and Wales made a presentation, drew up a memorandum of understanding with the Bar Council of India, but the MOU never saw the light of the day. All these are developments which have been happening along the way since the issue of liberalization has been in discussion. And we are today with the BCI rules, draft rules, which of course are the quality is, as Dr. Bashir mentioned, there's a lot of scope of improvement, and we'll see how possibly we could improve it. But first of all, is there a need for foreign law firms or foreign lawyers in India at all? And who are the stakeholders whom the legal services impact in India? Who are the stakeholders who would get impacted either way by foreign lawyers coming into India? I've tried to list out some of them. We could always add to the list from inputs from the colleagues here. First and most important class is the individual practitioners and senior counsels. This is possibly the largest body of legal practitioners in India who could directly or indirectly get impacted in some manner at some phase, if not in phase one, by having foreign lawyers practicing in India, depending on how and in what manner the foreign lawyers are allowed to practice in India. Therefore, whether they get impacted or not is something which will have to be kept in mind while defining the BCI rules. Law firms, as I mentioned, of various tiers, and I would always add a caution that law firms should not be qualified as a single tier. And when we talk about a team of law firms making inputs, they may be very big names, but they are not the names who represent the different tiers in the law firm fraternity, and that is a matter of fact. Therefore, although they are the best brains available in the law firm community, but there are other law firms of different sizes and expertise and tiers who could be impacted differently by the liberalization of legal services, and who also need to be able to put across their viewpoints in what the policy should take, what direction the policy should take going forward, because it's not the issue only about the BCI rules, it's a larger roadmap of liberalization of legal services. Students and interns, I think by having foreign law firms at our doorstep, and of course the foreign law firms possibly requiring talent from India to service Indian requirements of their clients, could open doors to a whole lot of opportunities for lawyers from law schools and for internships for students during their training phase. The faculty and law schools, as Dr. Bhasin mentioned, about the kind of talent that could be brought into the classroom for training, for curriculum. We have some institutions, I would not like to name as of now, but we have some institutions which kind of flag the involvement of foreign lawyers as a part of the faculty, and the curriculum includes transactional experience of foreign lawyers, which definitely puts them apart and different from the other legal institutions. I think this should be a norm rather than an exception that only a few institutions have it. With foreign lawyers at our doorstep, they could be far more accessible to law schools to improve the curriculum and quality of instruction in the classrooms. General counsels and legal heads, very clearly, whenever there is a need for foreign legal advice, one, it is superlatively expensive, and secondly, it is never accessible to a GC. It's always far away, and it's always very expensive. So I don't need to add more to say that it would definitely be something that would help companies and general counsels immensely by having foreign law firms at the doorstep, including the wider expertise that they could bring on emerging areas of practice in India, where we are still covering the miles. Another very important class of stakeholders is the ADR and mediation professionals. As Dr. Bhasin mentioned, somewhere there was an issue that to make India the arbitration and mediation hub. I think the goalpost remains, and the government does intend to make India as arbitration and mediation hub for Asia and Africa, and possibly the world, just like Singapore, Dubai, and other jurisdictions. To do that, how the ability of foreign law firms to practice arbitration in India is going to affect the entire development on this side, and therefore ADR and mediation professionals are very integral to what decisions are made on this very important issue. Let's have a look at, I've tried to give this a very bird's eye view without getting into too much of details about how liberalization has been permitted in different parts of the globe. We have all the countries listed out here permit international law practice by foreign law firms: Indonesia, Malaysia, China, US, Russia, South Africa, Singapore and Brazil. Apart from Indonesia and Malaysia, all the other jurisdictions permit local offices to be kept by foreign lawyers. On domestic laws, it's a slightly closed door, except for Singapore, which provides for collaboration with local law firms and therefore practice in domestic laws, and in other laws, China, USA, Russia and South Africa. On a few other facts, in Indonesia you need a work permit. I'm just mentioning all this possibly on what mechanism could evolve under the Bar Council rules or thereafter. In Indonesia, you require a work permit from the Minister of Manpower. In China, a foreign law firm can provide legal services